us at the Education Committee this evening. My name is Deirdre Bartman. I'm chair of the committee. I'm just going to ask that we just take a moment of silence, and then I'm going to introduce the members, and then I'm going to briefly take everyone through the public participation process. Through the public participation process, as well as the submission process. Sorry, if we can just all settle down a little bit. It might just be noisy with everyone coming in. Okay, I think this is the loudest the mic can go, so I'll try to project a little bit. So after introductions, I will then just briefly go through the public participation process, and then we are going to jump straight into the presentation, and then we're going to do the respective submissions. I will also explain the respective submission process. So if we can just all have a moment of silence. Thanks. Thank you so much. Members, if you can just please introduce yourselves.
Thank you, Chair. Good evening. Good evening to everybody. My name is Christopher Fry. I'm a member of this committee from the DA.
Good evening, everybody. My name is Ferlin Christians. I'm a member of this committee and a member of the ACDP.
Evening, everybody. My name is Connor Poole. I'm a member of this committee of the DA.
Good evening, everybody. I'm Pamela Harris, alternate committee member, and I represent the African National Congress. Thank you.
Thank you. And I do know that members Syed and Brinkhuis did submit their respective apologies. We are assisted this evening procedurally by Ms. Hassan Musa. She's our procedural officer. For those who don't know, procedural officer makes sure that our T's are crossed and our I's are dotted in terms of the Western Cape Provincial Parliament rules and procedure. Advocate Swansea, if you could just introduce yourself.
Evening, everyone. My name is Advocate Zungulan Chwanti from the Department of Basic Education, Pretoria, Legislative Drafting Component. Thank you.
Thank you. I'm just going to quickly take everyone through the legislative process. I know some people have been at a public hearing before, but some have not. So please do bear with me if you've heard some of this information before. Just in terms of logistics, bathrooms are down the corridor to your left. Should you want to step out for a cup of tea or coffee or refreshment, you can go straight down the lobby, and there are some refreshments in the lobby area. I'm not seeing Mr. Naidu now. I think I just walked past him when I walked in, but he's our Sergeant of Arms. I will show you what he looks like when I see him now again. If you have any safety and security issues or want to know where the exits are, but just a reminder, there's an exit when you walk out of this door to your left, as well as you walk around the chamber, there's an exit on the other side as well, should you need to leave the respective building. In terms of the legislation, before us today is a Section 76 bill. For those who don't know, the Constitution actually dictates how we deal with respective legislation. So the reason it's called a Section 76 bill is because Section 76 in the Constitution is the actual section and how we process this type of legislation. So at the start, what ends up happening is the Department of Basic Education nationally has written this bill. So you would have received a copy of the bill. Oh, here we go. And the National Minister of Education then introduces the bill, okay? That bill then goes to the National Parliament. So sometimes people get confused between the National Parliament and the respective provincial legislatures. In the National Parliament, it goes to the NA and the NCOP. Once it gets to the NCOP, what the NCOP has to do is it has to ask all 9 provinces in the country how its people feel about the respective legislation. So this is part of that section of the process where the Western Cape is asking the people of the Western Cape how it feels about the respective bill. Once we have concluded all of our public hearings and received all of our respective submissions, We as a committee then have to indicate, okay, we agree with these clauses or we disagree with these clauses or we want amendments to these particular clauses. And the committee then puts together what is called a negotiating mandate. Negotiating mandates are regulated by the Mandates Act of South Africa and how you put them together. And that then gets sent to the NCOP as essentially the Western Cape's position on the bill. Once it gets to the NCOP, the 9 provinces are required to negotiate with one another, which is why it's called a negotiating mandate. So let's assume 2 provinces said fruit must be sold in all schools, but the one province said only banana should be sold in the school, and the other province said only apples should be sold. So then the provinces essentially have to negotiate with one another as to maybe there's a compromise, or maybe this might be changed, or maybe someone had a better argument, etc. Once the NCOP has essentially completed that negotiation, that comes back with or without amendments, depending on what they have decided. Then we essentially have to look at what they've sent back, and we have to then submit what is called a final mandate based on what they sent back. I know in some other provinces, and we've heard in some of our public hearings, that people were told that members of the public vote. Members of public do not vote at a public hearing. That is not how a public hearing works. So I just want to make sure that no one is misled in terms of public voting on a bill. Okay. I just want to check if I've gone through. So today, members don't get to ask questions. Members are here to listen to the public. And when you look at, there are some court judgments on public participation, such as the Lamosa court judgment, such as the Mogale court judgment, not disregarding older court judgments, such as Doctors for Life, where members would have to then take respective public participation and meaningfully consider it when we put our respective mandate together. In terms of how the process this evening is going to work, Advocate Swansea from the DBE is going to do a presentation. So you would have gotten 2 documents. One is the actual bill, the actual clauses. The second one is a presentation on the bill. Okay, so the presentation on the bill is online, and you would have received a hard copy of the respective bill. In front of you, you will see there are mics. So when you do a submission, you just press and then the mic goes on, and you press again and the mic goes off. In terms of the Western Cape, we have 3 official languages in the province. So if you choose to listen or make a submission in English, Afrikaans, or Xhosa, you're welcome to do so. You can just put the headphone on like this. Or if you're in the gallery, it will be next to your chair. And you can then choose whether you want to listen in English, Afrikaans, or Xhosa. You can also make a submission in that regard. We accommodate all the respective official languages. If anyone is online, my understanding of the language setting is that you need 2 devices in order to listen to the translation on the one and listen to the normal one. But if you on YouTube, you'll only hear the English version. So if you're in the meeting, you'll be able to use 2 devices to hear the different language settings. To my knowledge, there's no one in committee room 2, which is our overflow venue, because I see we have enough space at the moment. Okay. When we make the respective submissions, I'm going to just give a few examples. So if you are from the parents associations that definitely want apples to be sold in schools, then you'll maybe say, hi, I'm Deirdre Bartman. I want apples to be sold in schools. I agree with this clause. I support the bill. If you're from the parents that don't support fruit in school, maybe you'll say, hi, I'm Deirdre Bartman. I don't support that fruit is sold in school. I disagree with this clause. I object to this bill. If you're maybe from the Parents Association for Fruit, you might be saying, okay, I'm Deirdre Bartman. Yes, we want fruit in schools, but we don't necessarily want apples. We want oranges maybe, because that's a better nutritional ingredient or fruit. And therefore, we would like the committee to bring an amendment to the bill. So that is more or less the process of making a submission. I'm also just going to indicate the written submission process. So you also have a right not to make an oral submission if you want. I know some people prefer not to speak in public. So I'm just going to indicate quickly the written submission process. The deadline for the written submission process is at midnight this evening. So if you have a pen or want to open your notes, it's also on the Western Cape Provincial Parliament website. The email address for written submissions is for whiskey, H for hotel, M for Mike, O for Oscar, O for Oscar, S for Sierra, A for Alpha, at wcpp.gov.za. I'm just going to repeat that, WHMOOSA at wcpp.gov.za. It is also online on our website. There's also an online submission form that we created. So if you prefer not to send an email, you can go onto the website and fill the online submission form in on the WCPP website and just click submit as well. We also have a WhatsApp number. The WhatsApp number, if you choose to make a submission over WhatsApp, is 081 498 6075. I'm just going to repeat that, 081 498 6075. And all of this information is also on the respective on the website. I just want to make sure that in terms of process, we're all on the same page. Okay. With that, Advocate Swansea, over to you in the presentation, and I'm going to put you on a 30-minute clock.
Sure.
And when we get to 30 minutes, I'm going to, that's the part I forgot to say. With the submission process, we give everyone opportunity to make a submission within 2 minutes, and I have this little old clock here that the procedural officer assists us with. I know it's not a lot of time, but we're trying to give people, as many people as possible, an opportunity to make a submission. And I just ask that if you've already made a submission, that you allow someone else to make a submission before you get a second bite of the cherry. Yes. Thank you so much. But I will just repeat and ask for assistance again when we get to the submission process.
Thank you, Chair.
Swansea.
Thank you, members, everyone. Good evening. May I negotiate 40 minutes, Chair? Seeing that we're actually dealing with 54 clauses in the bill, if possible. Thank you, Chair.
I know we're dealing with 54 clauses. To my knowledge, approximately 14 are technical matters. I just don't want us to end up at 50 minutes, and I would like members of the public to have much opportunity for input as possible. Obviously, if you go 1 minute over, I'm not going to punish you, but I just want us to be concise.
Thank you, Chair. Evening, once again. This bill seeks to amend 2 pieces of legislation, the South African Schools Act, as well as the Employment of Educators Act. This bill is not about curriculum. The Bella bill is not about infrastructure. The Bella bill is precisely about governance, management, relationship between school, SGP component, and the department. In clause 1 of the bill, you'll find a definition clause. Definition clause seeks to amend section 1 of the South African Schools Act. You will see terms or terminology like basic education. The bill is migrating from basic definition of basic education. You realize in the current South African Schools Act, it starts from grade 1 up to the last grade. Under this bill, basic education relates to grade R up to grade 12. Competent assessor, just an extension of the term, meaning it's an amendment to the term used in the South African Schools Act. Now it actually has incorporated a recognized professional in the field of education. You're going to find these terms as you go through the bill itself up to the last clause. Corporal punishment, there's an extension there in the definition, what we now mean by corporal punishment. Is that as well we're going to find in the bill. Special education needs, what that means for the purposes of this bill, because every terminology that you find under the definition clause, it's actually meant for the purposes of this bill. Clause 2 seeks to amend section 3.1 of the South African Schools Act, which provides for school attendance. Basic education now starts from grade R. Grade R is currently offered in most schools around South Africa. But the unfortunate part is that it's not recognized, meaning it does not benefit in the mainstream of the basic education sector. And to understand that, the educators or teachers who actually teach grade R are mostly on temporal basis. So this clause wishes to recognize grade R as a grade that will benefit within the education sector. Clause 3 provides for monitoring of school attendance. It has become a crisis. Learner dropout has now become a crisis. So this clause is saying where a child or a learner has been absent from school for 3 consecutive days, the educator or the teacher must inform the principal. The principal must investigate the whereabouts of this child, either by consulting with the parents, consulting with the guardians, to mitigate against learner dropout. Clause 4 seeks to amend Section 5 of SASSA, which provides for the intervention of the HOD on admission policy. I'm going to club Clause 4 together with Clause 5. This clause is saying the SGP component retains the power to develop both admission and language policies. No power is taken away. But that those 2 policies should respond to the aspirations of the Constitution, where it has been discovered that one of those clauses or one of those policies or both are against the provisions of the Constitution, the HOD must intervene. How is the HOD expected to intervene? The HOD must actually refer that policy back to the SGP component and request audience and request the SGP component to review or reconsider the policy itself. Before further steps are actually taken, that process must first be undertaken. What this clause is saying, the HOD cannot just dismiss that policy. That process must first be satisfied. That's all this clause seeks to achieve. Both clause 5, admission, clause 4, admission policy, and clause 5, language policy. Remember what actually triggered the amendment to SASSA around this clause, court judgment. These 2 clauses, 4 and 5, language and admissions, they've been litigated upon from the High Court, Rivonia versus MEC Gauteng, up to the Constitutional Court. So that triggered the amendment of these 2 clauses. As I mentioned earlier, clause 5 as well seeks to amend section 6 of SASSA, which provides for the language policy, where the language policy is found to be against the aspirations of the Constitution, the HOD will intervene. There is a safety net, in fact, already under the South African Schools Act 12.9, where the MEC, where the police is found wanting, the MEC can intervene. Clause 6 seeks to amend section 6A of SASSA, which empowers the minister to appoint outside agencies or persons to advise the minister on curriculum. We evolve in society as well as curriculum. A need might actually arise that, look, we need to change this school to an engineering school, motoring school, or aviation school. There's no one with such expertise within the education sector. So this clause is saying, where a need arises, the minister now can co-opt any person with the relevant expertise to advise the minister, or even an organization to advise the minister in developing a relevant curriculum. Any person with the expertise, the minister now is empowered to seek assistance from such person or expert to assist in the development of the curriculum. Clause 7 seeks to amend section 8 of SASSA by providing clause 7 that only it's actually about code of conduct. This clause is saying when SGP components now, when they are developing their own school of conduct, they must be sensitive to the Constitution. They must actually understand that learners within school settings come from different religious backgrounds. They come from different customary backgrounds. So that code of conduct should be sensitive to such. There's case law in respect of that as well. Clause 8 seeks to amend section 8, capital letter A of SASSA, which actually relates to random search and seizure. There is currently a relationship between SAPS and education sector, where police can just enter a school with a reasonable suspicion that a group of learners or a learner is in possession of an item that's not actually permitted within a school setting. It can either be a drug, a weapon, or whatever. But now this clause is saying when a reasonable suspicion has been established by a school, in the absence of SAPS, a school can undertake or initiate that search and seizure. That's all this clause is saying. Clause 9 seeks to amend Section 9 of SASSA by providing a list of acts of serious misconduct and clarify constitute an act of misconduct. That clause is actually saying before a learner is suspended or later or expelled from that school setting, there must have been a grain of evidence that can be presented to get that learner suspended. Because currently now, the SASSA says upon reasonable suspicion that the learner must have actually misconducted themselves. It has been realized that a learner will actually stay at home for a lengthy period, and later it will be discovered that a learner is actually innocent. So a grain of evidence must actually be presented for a learner to be either suspended or expelled from a school setting. Clause 10 seeks to amend Section 10 of SASSA, which provides that corporal punishment is abolished. Corporal punishment is abolished, and an educator can actually be charged in terms of the Criminal Procedure Act. Remember, each and every piece of legislation operates in actually collaborates with other pieces of legislation. It does not actually operate in isolation of other pieces of legislation. But now, this prohibition has been extended to when an adjudicator, as a form of punishment, provides a name calling to a learner or tells this learner to clean public or school toilets as a form of punishment. That is now another form of corporal punishment. It now extends now to beyond whipping. Clause 11 seeks to amend Section 10, capital A of SASSA, which prohibit initiation. Remember, the practice is actually there, most especially when learner moves from primary to high school. This clause is saying this prohibition remains actually intact even if a school is actually out on excursion. It extends to the hostels where learners actually reside, not only within a school setting, as per the legal term of Clause 12 seeks to amend Section 12 of SASSA, which provides that SGP of public school may apply to the MEC to be designated as a public school with a special focus. This clause is saying when SGP component deems it necessary to convert or to change a school from normalcy to a specialized school focusing on talent, they can do that through an application process. The MEC as well, when they deemed necessary to convert a school to a specialized school focusing on talent, they can do that, but the processes that must first be undertaken are such that consultation should actually be satisfied. All stakeholders within the education sector should be made aware of this intention, and they should look consultation. The department cannot just wake up in the morning and shall decide to do such. Clause 13 seeks to amend Section 12, capital A of SASSA, which provides that in instances where two or more schools are merged, a new public school will be established. But there are processes before a school is either merged or closed. There are processes that must first be satisfied. More especially factors. What's going to happen to those learners who used to attend to that school before it gets merged? What's going to happen to those learners where school is actually closed? Is there transportation available for the learners in terms of being actually transported to the new school? What's going to happen to the uniforms? Those considerations should first be considered before a decision is implemented. If the department cannot actually satisfy such factors, those schools should remain open. Clause 14 seeks to amend Section 21 of SASSA by putting an enabling position for central procurement. This clause is saying where school A, B, C, and D share the same interest in purchasing a particular item, the department can actually undertake that process and try to procure that item for all schools at a discounted rate. However, a school or SGP component can choose to co-opt from that process. If a school or SGP component chooses to co-opt from that process, that item, the school must buy that item at a price that is cheaper than the department would have acquired that actual item for. That's the only trick. Clause 15 seeks to amend Section 22 of SASSA, which empowers the HOD to withdraw on reasonable ground any function of the SGP component. Again, there are processes that must first be entertained and satisfied. HOD cannot just withdraw functions from the SGP component. The SGP component must be given an opportunity to state their case, out the alteram paterem rule. The other side of the story should also be heard. What went wrong and how, which is a possible way to remedy the mischief. But what is important, that the HOD cannot just withdraw any function from the SGP component unless those processes are satisfied. Must be given an opportunity to state their case. Clause 16 seeks to amend Section 23 of SASSA, which empowers the governing body to co-opt any person from outside the community. This clause is saying where the SGP component is unable to fulfill their mandate, and there is someone with the relevant expertise who can come and assist this SGP component, the SGP component is now empowered to co-opt any person, even if that person is not a parent to any child attending school within that community area. SGP component now can co-opt any person with the relevant expertise, that person who can assist the SGP component in fulfilling their mandate. Clause 17 seeks to amend Section 24 of SASSA, which empowers the minister to determine on National Gazette the number of SGP members. For the purposes of uniformity, the minister felt, there are policies now in different provinces. Each province has actually a policy on the election of SGP members, which actually contradicts another policy from another province. So minister is saying, for the purposes of uniformity, this process of developing a policy on the election of SGP members will be coordinated from the Ministry of Education, meaning national. Clause 18 seeks to insert Section 24A to regulate membership of governing body of public school within a special focus on talent. The same process, uniformity. That process will be coordinated from the ministerial level. Clause 19 seeks to amend Section 25 of SASSA, which empowers the HOD to dissolve an SGP component. The HOD cannot just dissolve the SGP component. That component must be given an opportunity once again to state their case, why they had failed in fulfilling their mandate. They must be given an opportunity to try to amend the mischief. Clause 20 expands on the provision of Section 26 of SASSA, which provides for the recusal of SGP members. As an SGP member, if you do business with the same school that you represent through the SGP component, you must recuse yourself. You are conflict of interest. Not only you as an individual, as an SGP member, your wife, your kids, and for the purposes of transparency, for the purposes of good governance, and for the purpose of accountability, recuse yourself if you are conflicted. This is what this clause is saying. Clause 21 seeks to amend Section 27 of SASSA, which provides that no member of governing body may be remunerated in any way. Remember, by virtue of being a member of the SGP component, you're not entitled to salary. But if you spend money by pouring petrol or by faring a taxi in order to fulfill the mandate of the SGP component, you must be remunerated for that expense. Otherwise, we are not salaries by virtue of being a member of the SGP. We are trying to avoid a situation where people fight over position within the SGP component. Clause 22 seeks to amend Section 28 of SASSA, which empowers the minister to determine the election of members of the governing body. This authority under the current SASSA is actually entrusted under the MEC. The minister is saying, again, for the purposes of uniformity, let me take charge of this responsibility through the education minister at national level. Clause 23 seeks to amend Section 29 of SASSA, which provides that where reasonably practical, only a parent member of the governing body who is not employed within the public school can become the chairperson of the finance committee. Only a parent, not someone employed within that school, for the purposes of transparency. Only a parent can become the chairperson of the finance committee of that SGP component. Clause 24 seeks to amend Section 32 of SASSA, which regulates the status of learners. Remember, learners at high school are actually allowed or permitted to be members of the SGP component, but there are only 2 instances where they are not permitted to partake. They are not allowed to sign contracts. When I speak of contracts, I'm actually making reference to lease agreements, to overdraft agreements, to loan agreements. By law, a learner or a child is not permitted to enter into any kind of a contract. Secondly, they are not permitted to partake in the processes of employing educators. One wishes to see a situation where learners that actually training teachers that, look, I employed you, don't forget. You know how they can actually behave in such instances. So they're not actually permitted in 2 circumstances: to partake in the development or in the signing of contracts. Secondly, in the employment of educators, learners. Clause 25 seeks to amend Section 33 of SASSA, which deals with the closure of public schools. As I said earlier, the merger and closure of schools. Before a school is closed, the HOD must have consulted with the relevant stakeholders within the education sector. The public must actually be made aware of this intention before the decision is actually implemented. What's going to happen to those uniforms? If schools now, this school is closed and learners are expected to move to another schools, what's going to happen to uniforms? Parents cannot actually be exposed to paying or buying 2 sets of uniforms, 3 of them or 4 within the same year. What's going to happen where a school now is actually over a river? Are we still going to close the school? If the HOD, if the department cannot actually satisfy those concerns, those schools should remain open. Clause 27 is just a technical kind of amendments from directions to directive. Clause 28 seeks to amend Section 38 of SASSA, which provides that a document explaining the budget of a school, together with the budget itself, must be made available to parents. Before SGP component calls upon a meeting, parents' meeting, to explain the finances of a school, parents should be given 14 days in advance. And within that 14-day period, there should be actually the finances or financial statements of the school should actually be availed to parents so that they acquaint themselves with the finances of the school before a meeting is convened, 14 days in advance. Every cent spent by a school, parents should be made aware of it. Any transaction taken into by a school, parents should be made aware of it 14 days in advance before a meeting is closed. SGP component cannot just come. Parents will be calling upon a meeting the following day. It doesn't look like that anymore. Clause 29 seeks to amend Section 38, capital letter A of SASSA, which extends the application to a state employee who is paid any additional remuneration or any other financial benefit or benefit in kind. SGP component can actually take a decision to actually incentivize any member they actually wish to do so. They can do that. That power is still there. It retains with them. But for the purpose of accountability, that expense should be reflected on the finances of the school. And the reasons why this person is actually incentivized. Clause 36 to amend Section 41 of SASSA, which regulates the exemption of a single parent to provide government support. There are instances where parents are actually in a position where parents are actually in a position that I cannot actually pay for school fees anymore. The parent, in the absence of the relevant documentation, can now go to a police station and dispose of an affidavit. That affidavit must be submitted to a school explaining actually the circumstances where a parent cannot afford the school fee anymore. And that school must accept that affidavit. And there are instances where a school will actually retain or withhold a child's report. That is illegal. That is illegal because the contract is not between the learner and the school, it's between the parent and the school. That child should continue going to school. Clause 31.6 to substitute Section 42 of SASSA, which provides that SGP or public school must keep detailed records on prescribed aspects of financial affairs. The same as the one that I just read now. Finances of a school should actually be available to parents, and they should always be updated. Clause 32.6 to amend Section 43 of SASSA, which empowers now the HOD on where it has been established that financial misconduct has been actually is taking place at that school or within that SGP component. The HOD can initiate investigation, can call upon investigative agencies to pursue investigations as to what had happened to the finances of that school or any financial misconduct that actually happened at that within that SGP component. Clause 33.6 to amend Section 46 of SASSA. The objective of the amendment is to increase the penalty provision for any person who operates a non-registered independent school. This clause is about registration of independent schools. If you are running an unregistered independent school, you're going to be charged. If you run an unregistered independent school, you will be charged under this provision. Clause 34.6 to amend Section 48 of SASSA, which provides that the subsidy granted to an independent school can be made subject to conditional determined by the MC. Yes, if that school, independent school, is registered. And secondly, quarterly reports must be submitted as well with the department for any independent school to qualify for subsidy. Clause 35.6 to substitute Section 51 of SASSA, which provide for clarity with regard to home education. Section 29.3 provides for any parent to homeschool their kids. It's a constitutional provision. You can home educate your child. You can choose the curriculum that you wish your child to be exposed to. However, that curriculum should never be inferior to the curriculum offered by the state. Secondly, that child must be assessed by an independent assessor. Remember, migration from one grade to another. That child should be exposed to a curriculum that is on par with the curriculum offered by the state, never inferior. That child should be assessed by an independent assessor, and that homeschooling process should be registered with the state. Because of Section 29, every child should be at school. The state should know that this child is not at school, however, home education is actually offered for this child. How does the state will know that? Through registration. Section 28 of the Constitution, a protection of every child's welfare. Clause 36 to amend Section 59 of SASSA, which provides for an offense and penalty against a parent or any person who submits false or misleading information. Remember, I said earlier, you want to apply to a school for an exception that you can't afford school fees, or you want to apply to a school that you stay within the area where the school is actually based, and you provide falsified information in those application forms, you're going to be charged. Remember, you'll be expected to depose of an affidavit, meaning you state whatever circumstances that you're going through under oath. You'll be charged with perjury. You submit falsified information for an exception, not to pay school fees, or to get your child admitted to a particular school, you're going to be charged if you are found. Clause 37 is a new insertion to Section 59, capital letter A, SARS will provide for dispute resolution. That was actually decided in the case that actually involves language and admission policies. Rivonia versus MEC Gauteng, High Court up to the Constitutional Court. The Constitutional Court said, when there is a dispute between the stakeholders within the education sector, they must first find themselves before they litigate. Litigation is not cheap, and it's always to the expense of the learner, and it takes long to conclude cases. So this clause is saying, before parties or stakeholders within the education sector think of litigating, they must exhaust the internal processes within the education system. Hence, the provision of this clause, dispute resolution processes. Clause 38 seeks to amend Section 60 of SASSA, which deals with the liability of the state. This clause is saying, if an SGP component conduct itself outside the South African Schools Act, the state for any consequences will never be liable. Ultra vires. Clause 39 seeks to amend Section 61 of SASSA, which empowers the minister to promulgate regulations on learner pregnancy. Currently, there's no document that educators or teachers can use in the management of learner pregnancy. And learner pregnancy has become a crisis. Learner pregnancy has become a crisis. The minister is now saying, parents, stakeholders within the sector, give me permission so that I speak to my colleagues at the ministerial level, particularly the Minister of Health, and check if we cannot actually get a nurse that can be dedicated to these schools where there are learners who are actually pregnant, so that this actually nurse can monitor this pregnancy. Because what has been discovered, learners give birth at school in full view of other learners. So the minister is saying, give me permission so that I speak to my colleagues, so that a document for the management or that will assist educators within a school setting how to manage learner pregnancy. A nurse can actually advise the school as well when the learner is due to deliver. But look, this learner's pregnancy has actually advanced. Would actually suggest that this learner stays at home, then education processes will actually continue while the learner is at home, as opposed to learner giving birth within a school setting. During our public hearings, we've actually gathered concerns that people are actually saying that the minister intends on advising learners to abort. There's nothing about that. The Minister of Basic Education is not empowered constitutionally to speak on anything that has to do with medical-related issues. Minister is not constitutionally mandated. Only the Minister of Health can suggest or provide any advisory on medically related issues. The minister is saying, help me develop a document that can assist educators. Remember, educators or teachers are never trained to deal with pregnancies. They are never trained. They are not trained. There's no document at their disposition, in fact, to deal with as to how to deal with men or how to manage learner pregnancy. All the minister is saying, give me that permission so that I actually speak to the relevant portfolios within government, where a nurse, if possible, can be actually to be allocated to this school, who can assist in advising this school on what to do in dealing with the learner who's pregnant, not the education sector. Clause 40 amends the preamble of SASSA. Remember earlier, SASSA, the Department of Education used to be Department of Education. Now it's actually saying, since the split, there's basic education and higher education. Then clause 41 up to other clauses are all about Employment of Educators Act. Those are just technical changes. But the interesting clause here is clause 49. Clause 49 is actually a new insertion which prohibits educators to conduct business with the state. This clause is saying an educator may, discretionary, may not conduct business with the state until this business interest has been registered with the state. Meaning the state must be aware that educator so-and-so has a business of this nature to mitigate against any conflict of interest. You cannot do business with the same school that you work for. And the state must know, this clause is not saying an employee cannot actually do business with the state, but you must disclose that kind of business that you're actually doing with the state. That's all. Thank you for hearing me out. I hope I'm within time.
Thank you. You're a little bit over time, but not to worry. It's important that we are able to indicate to people what DBE wants so that they can make their respective submissions appropriately. I'm told that we have gone into the overflow committee room 2 as well. I know that testing of sound has been done and they will be able to hear us in committee room 2. And I know that there are officials assisting. Just for procedure, this is Mr. Daza next to me. He's one of our senior procedural officers, just because Ms. Hassan Musa was just breaking her fast during this time. So we give her that time. Colleagues, what I'm going to do is it's similar to the previous session for those who are watching, but I'm just going to repeat. So I'm going to take hands in the chamber. While I take hands in the chamber, those who are in the gallery who wish to make submissions, I'm going to ask you please come down so that we're able to hear your respective oral submission. It is only because there's no microphone upstairs. There's listening abilities upstairs in the gallery, but there's no microphone upstairs. So those who wish to make an oral submission will just have to move downstairs to the chamber, and then I'll take it in the chamber comments first. Then I'll take the gallery comments. Then I'm going to take the comments from committee room 2, and there will be officials that will assist us with putting the video on and the mic and so on. And then I will take the comments online, and Mr. Daza and or Ms. Hassan Musa throughout the evening will assist. Just a reminder, and we're putting a 2 minutes on your respective submission. I know that people have various different views on this particular bill. I do ask that once the timer goes off, I'm going to ask that you please just conclude. That essentially means just conclude your sentence or your thought process, or if you haven't said yet whether you support or object or want an amendment. I'm not trying to be mean when I ask you to conclude. I really just want to give as many people as possible an opportunity to make an oral submission. So it does become difficult if when I say please conclude and then it is disregarded, because it's not fair towards others if I give you 3 or 4 or 5 minutes and others don't get the same opportunity. So please just ask if you can all work with me in this regard, as we are quite a number of people at the moment. What I'm going to do is I'm going to take the hands and I'm going to give you numbers. So please just remember your numbers, because I'm not going to be able to remember everyone's name. And then I'm going to take the hands on this side. And then as people come down to use the mic, I will take those particular hands as well. Okay, so I'm going to just start seeing hands now. Yes, no, okay. Okay, just everyone just put up your hands first if you want to make an oral submission. Okay, 1, 2, 3, 4, 5, 6, 7. Before I get to this side, I want to make sure those are all the hands. Okay, if there's no, I think I did give to yourself. Okay, so 1 to 7 is on my left. Okay, then the hands at this side. Okay, 1 to 8. I'm going to give you number 8. Okay, just so that I don't want to come back afterwards. Okay, the hands here. Okay, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. I did see your hand, ma'am. You are number 1 on this side. So once we finish with 1 to 8, I'll start with 1 to 10 on this side, then on the right side. Then once those are concluded, persons can start making their way towards the chamber, and then I'll take the hands from the gallery. We'll then take the hands from the committee room too, and then we'll take the hands online, which the procedural officers will assist us with. With that, sir.
Thank you. Are you hearing properly? Okay. Members of the committee, thank you for giving me the opportunity to speak to you, and I greet everybody here and the teachers who I'm sure are doing a tough job, and we acknowledge that there are things that are addressed in this bill that many teachers are and the government minister and others are needing to be addressed. However, sorry, I forgot to note my name is Brendan Tennyson. I see numerous problems scattered throughout the bill and don't support it as a whole. Particularly concerning to me are the clauses that encroach on the rights of parents and school governing bodies, clauses that prescribe the content and curriculum to independent schools and homeschooling families, despite what has been said. Clause 35 has been written without adequate understanding of the science and art of homeschooling or meaningful consultation with the substantial homeschooling community in South Africa. Subclause 16 of clause 35 is insidious. It leaves the minister with unfettered power to make rules for home education without due democratic process. In short, the bill is an abusive overreach by the state into areas that should be rightfully left to parents and other dispersed authorities instead of centralizing control. Many of you suffered under the apartheid regime in which people like me were taught that others were inferior simply because of the color of their skin. That abusive state made sure to control the education of the children and shape the development of their ideology. A host of other oppressive regimes have done the same. Centralized government control of education will ultimately and almost certainly be abused. So citizens, I plead with you, don't give up your rightful liberty, no matter how good the state's intentions may seem to be. I respectfully call on Parliament to go back to the drawing board, to demonstrate proper diligence in consulting parents, homeschooling families, and the entire spectrum of innovative, independent educators, and to make full provision for all of these rich contributors to the well-being of our children and our country, to make provision for all of these varied strategies and styles and curricula, and to do so without centralized government meddling and hindrance.
Please conclude.
I call on Parliament to show restraint and hold itself back from usurping the sovereign and internationally recognized, historically proven primary right of parents to determine how and what they teach their children. Thank you.
Thank you so much. Lucky number 2.
Thank you, Chair. Chair, my name is Jetik Fortran. I would like to inform you that the EFF in the Western Cape supports this education bill. We would like to make amendments regarding the sale of liquor during school hours. There must be no sale of liquor at schools. The clause must be structured out completely. Termination of pregnancy and children given the chance of termination of pregnancy, that clause must also be structured out. In terms of the SGBs is a very big headache. We want you to take note that SGBs make laws at schools or in terms of who is allowed to go to their specific schools. And we want you as government to take away that power in terms of SGBs, giving the power to them, making decisions on behalf of government to see that only a certain amount of children should be allowed into their classrooms, while other colored schools are having children like in the classroom that are more than 100 children in a classroom, like in the white schools. There are 30 children in a classroom, which means is now we are overloaded. So we want you to take this amendment and put it also into the bill, that we support the bill and that these amendments should be placed on the record. Thank you, Honorable Chair.
Thank you so much. Lucky number 3. Let me just
Good evening, everybody.
Thank you.
My name is Brent Norris, and I'm a father of 6 children, of which 5 are currently homeschooled. I oppose the better bill, specifically Clause 35, which deals with the need, not only it deals with the need for approval, not only registration from the head of department for me to homeschool my children. I believe this infringes on the right as a parent to decide what is best for my children. I also reject the idea that an assessor deemed competent by an organization that is unfamiliar with the curriculum or learning outcomes can accurately assess my children at my cost. I would encourage greater engagement between the DBE and the homeschooling fraternity before such draconian laws are put in place. Thank you.
Thank you so much. Lucky number 4.
Honourable Baartman and members, thank you for the opportunity to comment tonight. My name is Sannelie van Niekerk and I reject the Bella Bill, specifically Clause 35. We are a homeschooling family passionate about quality education, critical thinking, and making a positive contribution to society where both parents are involved, and my children have all realized the importance of quality education and are therefore intrinsically motivated to want to learn. Both the Children's Act and the Bill of Rights states that it is my parental responsibility to see to the best interest of my children. The Bella Bill gives the Minister a broad scope in making regulations on home education, where the Minister can change any requirements as stipulated by the Bill, which in effect gives the Minister unlimited power over parents and their children. Where is my children's best interest in that? I believe the biggest concern of home educators is the threat to our choice of curriculum freedom. Despite numerous statements by the DBE that homeschoolers will enjoy this freedom and it is not about the curriculum, the bill never states freedom of curriculum explicitly, and the requirements expressed in the bill with regards to similar content and skills, as well as assessments to a standard not inferior to the national curriculum by a competent assessor who only knows the national curriculum, belies this freedom. This will be an infringement on my children's right to receive an education that is in their best interest. Our home education focuses on the 21st century skills that our children will need to function in the workplace. Forcing them to be subjected to standardized assessments of a national curriculum will prohibit them from realizing their full potential to be adults who contribute positively to our society and economy. We believe in the truth of Albert Einstein's words. Education is not the learning of facts, but the training of the mind to think. It seems like the educational department would not like us to think for ourselves. I urge this committee to allow us as parents to lawfully educate our children while ensuring that our children's best interests are always the priority. Let us take hands in uplifting our society instead of dragging it down even further by taking away our responsibility as parents, and in so doing, placing an extra demand on the already overburdened resources of the public school system. This will ensure a rich and well-educated society where our children, the future, can flourish. Nelson Mandela said, "There can be no keener revelation of a society's soul than the way in which it treats its children." Thank you so much.
Number 5.
Eerbare voorsitter en lede van die komitee. Skus tog, begin ons nou.
Jammer, daar's net as ons net die een mikrofoon net af kan sit asseblief. Baie dankie, u kan aangaan.
Eerbare voorsitter en lede van die komitee, my naam is Boue van der Eems, 'n tuiskoolpa van 5 kinders. Sedert 2001 was ek betrokke by verskeie tuiskoolorganisasies. Graag deel ek enkele waarnemings. In 2014 het die Wes-Kaapse onderwysminister, meneer Donald Grant, 'n tuiskoolbeleid gepubliseer vir kommentaar. Dit was ontwerp om tuisonderwys te transformeer in onbekostigbare staatsonderwys tuis. Ouers benodig toestemming om hulle eie kinders te leer. Ouers moet die minister se kurrikulum volg. Ouers moet opdok vir gereelde assessering. Honderde ouers het heftig gereageer en binne 3 weke het meneer Donald Grant die beleid teruggetrek. Donald Grant se tuiskoolbeleid verskyn egter in die Bellable toe die DBO dit in 2017 publiseer. Hoe werk dit? Adjunkminister Enver Surti sê in die parlement, "The Western Cape has been part of the legal team that had crafted this bill." 'n stortvloed van 5000 briewe oorspoel die DBO. 'n jaar later verskyn die Wes-Kaapse beleid in die nasionale beleid oor tuisonderwys. Toe ek gaan praat met die Wes-Kaapse onderwysminister, mevrou Debbie Schuyfer, sê sy vir my, sy ondersteun die beleid. Sy is verantwoordelik vir tuisonderwys. Tuiskolers moet na haarpype dans. In 2022 verskyn die Wes-Kaapse beleid weer in die Bellable. Meer as 50.000 ouers reageer. Met behulp van die Wes-Kaapse lede van die regspan van die Bellable, hou die parlement dit in klousule 35. Ek sluit af, as die Bellable wet word, gaan die bekwame Wes-Kaapse bureaukrasie elke jota en titel afdwing. Gaan tuisonderwys in die Wes-Kaap gevaarlik raak. Die Wes-Kaapse regering staan nou by 'n kruispunt. Gaan dit die Bellable teenstaan, maar later met mening implementeer? Of gaan die Wes-Kaap regering van rigting verander? Gaan dit onttrek aan die Bellable se regspan? Gaan dit provinsiale magte gebruik om weg te breek en 'n regsomgewing te skep waar tuisonderwys kan floreer? Ek dank u.
Thank you so much. Next is lucky number 6, but also just for everyone's knowledge and for the record, the Western Cape Education Department did make a written submission that they do not support the bill, which is part of the matrix. And to my knowledge, it is also publicly tabled at the NCOP and the NA previously, should you wish to read it. Number 6.
Thank you. So my name is Johan Kruger. I'm a homeschooling father of 5. I read clause 35, and it's a very woolly clause. It talks about the best interests of the child, as if the government knows the best interests of the child better than the parents. I can assure you that home educating parents are passionate about their children. This clause 35 gives the government unfettered power to refuse people to homeschool or home educate. I would suggest that this clause is objectively measurable, that if children meet the standards in language, maths, and science, then home education can be continued, and that should be written into laws that nobody can subjectively challenge people to home educate. Subjectivity breeds distrust and is open to the abuse of power. I would also like to make a comment on the curriculum. It talks about a curriculum comparable to school curriculums without limitation whatsoever. I would suggest this is also limited to maths, science, and languages, because those are the critical skills that people need to take into the world in order to be successful. Everything else is subject to diversity. This government says it loves diversity. Well, that doesn't seem to come out in clause 37. And finally, on this clause, jail time for parents for non-compliance is completely out of order. It can destroy families and careers and incomes and should be completely taken out of the bill altogether. We are not criminals. Nobody in this country that home educate their children is a criminal. If somebody treats their children so badly that they deserve jail, there are other laws in which to prosecute them. The addition of, furthermore, the addition of grade R to schools that are overcrowded, I think is nonsensical, can't be afforded, and the government has bigger problems that it has to solve. I think the disappearance of cottage schools, which relieve pressure on the system, is a tragedy, and those schools allows pools of teacher skills. I would submit to you that many of the problems that the Bellable tries to solve will be solved if the government uses misappropriated funds, as evidenced by the Auditor General's reports every year for the last 20 years, and build extra schools so that they can be accommodated and that class sizes can be smaller. Thank you very much.
Good day. I'm Oleander Oaks from the DA.
Which one?
Sorry, it was the lady in the white. Was number 7.
7.
Okay, what I'll do is,
Okay,
As
fine.
number
Thank
5.
you know what I'll do is, colleagues, what I'll do is you can go first, and then I'm going to take you, and then I'm going to take the little gentleman after yourselves. Thanks. Just hang on. And you can also bring the mic a little bit down if you wish.
Thank you. I hope that I can address the meeting in Xhosa. Ndingusibongile Kwazi, ilungu likaSATU. Siyawuxhasa, siyazixhasa as amendments zebhela bill. Okokuqala, siyayixhasa universalization ka-Grade R.
I'm sorry. I just quickly want to remind people about the channels. So if you wish to listen to it in English or Afrikaans, then you just put your little mic on and then you choose the channel. I think, Mr. Walter, just if you could Okay, Mr. Walter says to me in my ear he's speaking to channel 1 in Afrikaans. Mr. Walter, if you can just say to me yes quickly. Okay. I'm hearing Mr. Walters on channel 2 on this device here. Okay. Remember, Fry also says Mr. Walters on channel 2 and he's translating in Afrikaans. Then Mr. Sandele, I just want to check on which channel are you? Mr. Sandele is on channel 6. That is from isiXhosa to English. Okay, Mr. Sandele is telling me my ear here. That is correct. Okay. So if you want translation from isiXhosa to English, that is channel 6. And isiXhosa to Afrikaans, that is channel 2. Thank you. Can we just restart the clock quickly for Thank you. You may continue.
Ndingusibongile Kwazi, ophuma kwiSATU. Siyazixhasa ezi amendments kwi-Basic Education Laws Amendment Bill. Okokuqala, basithetha ngokuqukwa kuka-Grade R kwinxalenye ye-Basic Education. Sivula amathuba abo bahlelelekileyo ukuba bafumane i-foundation eluqilima ukwenzela ukuba nakubo kube lula ukuqhubeka phambili ngemfundo yabo. Siyayixhasa i-universalization ka-Grade R. Loo nto iza kwenza okokuba nabafundisi-ntsapho abakwa-Grade R bafumane izithuba zengqesho ezisigxina ukwenzela into yokokuba imisebenzi yabo nabo ikhuseleke. Ngaphezu koko, kwiikrithi zethu zasekuhlaleni, izinto ezifundiswa abantwana azikho semgangathweni kwezinye zeekrithi zethu. Ukuyuniversalayizwa kuka-Grade R uza kwenza i-foundation eqinileyo for abona bantu basokolayo. And ndiqinisekile abona bantu baninzi kweli phondo ngabo basokolayo. Siyaphinda siyayixhasa, kodwa sifuna nje ukwenza i-amendment encinci kwi-criminalization yabazali abangabathumeliyo abantwana esikolweni. Kukho izizathu ezahlukeneyo ezenza uba abazali bangakwazi uba ne-control yokuba abantwana babo bayasingena isikolo. Endaweni yokokuba senyuse ifayini okanye ixesha lokubanjwa kwabazali to i-12 months, sinesiphakamiso sokokubana masihlale kule fayini ikhoyo ngoku. Inye into ekufuneka siyiqinisile kukuba makuqeshwe amagosa azawuhamba phakathi kwiindawo zethu ezilokishini zethu athi make sure ukuba abantwana basezitrateni bayahamba baye esikolweni. Siyayixhasa kwakhona into okokubana mayireguleyithwe i-homeschooling. Ukuba ithi i-South African Schools Act ucompulsory uba abantwana bane-15 years okanye ugrade 9 ukuba babe sesikolweni, kufuneka kubekho indlela
yokokubana inyanzeliseke loo nto. Okokuba abazali ngoko ababhalise abantwana babo abafunda imfundo yasemakhaya. Urhulumente akazuba nawo amandla wokwazi ukuba ngobani abantwana abangekho sezikolweni. Kufuneka ayazi uba kukho abantwana abafundiswa emakhaya. Ngaphandle koko, kufuneka kube khona ii-minimum standards ezisethwayo ku-homeschooling. Ngoba kaloku ayingabantu bonke abanemali yokuqesha ootishala abafundileyo okanye aboqesha izipeshalist. Bazawuba khona abantu abanomdla okokuba abantwana babo babafundise ekhaya babe bengenazo izakhono. Ngoko kubalulekile okokuba kubekho ii-minimum standards. Enkosi.
I just want to say thank you to Mr. Sandele for his absolutely amazing translation. For those who don't know, we have translation services in the WCBP for every committee and every sitting all the time. And all of our papers also get published in the respective languages. So I just want to say thank you to our translators who do an absolutely amazing job. Ma'am in the blue.
Thank you so much. Oleander Oaks from the DA. The DA unequivocally rejects the Ballot Bill in its current form. While we support educational reform, especially given the current state of the basic education system, the Ballot Bill not only fails to address the major reasons for the South Africa's lack of quality education, it also disregards the majority of public submissions which rejected the bill during the public participation process at the national level. Instead of addressing overcrowding, curriculum failures, dropout rates, unsafe and unsanitary educational facilities, poor quality teaching, and a lack of resources, the bill focuses on centralizing power toward the national government and disempowering parents and communities. Our concerns. Mandatory grade R, we refer to clause 2. While the DA supports the intention of compulsory grade R, the Department of Education does not have the 12 billion rand needed to implement grade R learners. The implementation of this clause might cause cuts to other struggling but vital programs like the National School Nutrition Program or the Learner Transport Program. This also comes at a time at which the fiscus is especially constrained. Already, education departments across the country are having to make massive spending cuts because of the national government continuous mismanagement of public funds. Admission policies. The DA opposes removing the power of determined admission policies from school governing bodies. The administrative burden on the HOD to approve every admission policy in the province would be immense and impractical and can lead to abuse of power. Notwithstanding the above, the added red additional bureaucratic processes will delay schools from finalizing their language policies. More than this, the local community and its school governing body will be best placed to determine and appreciate admission policies as they have the best grasp of their needs.
Please conclude.
With regards to the notable exclusions, just wish to note, blended and online learning. Despite the DA continuously raising the bill's failure to include blended and online learning, this has not been addressed. The COVID pandemic has shown the importance of these forms of education, and any comprehensive legislation should include both. In conclusion, Treasury does not have the funds for the mandatory grade R implementation. The public participation submissions were not taken into consideration. The National School Nutrition Program was mismanaged with delayed stock delivery and funds being used for other purposes. In the presentation to the Parliament, the Auditor General also highlighted systematic basic education failures, none of which are addressed by the Ballot Bill. The Ballot Bill focuses on centralizing power, holds to much risk of abuse, and its failure to address the systematic issues that plague the basic education in this country does not bode well. I thank you.
A young gentleman at the back.
Goeienaand dames en here, ladies and gentlemen. Ons het tuisonderrig want ek weet ek kan sien my pa ma dra my beste belang op die hart. intellektueel, emosioneel, akademies en geestelik. Hoe kan ek weet die onderwysdepartement kan dit waarborg as daar soveel leemtes in die huidige skoolopset is? Die Bella-wetgewing wil hê die departement moet kan besluit is dit die, wat is die beste vir my, maar hulle ken my nie. En as my ouers en die departement verskil, kan my pa in die tronk gaan. My pa is nie 'n krimineel nie. Dankie.
Thank you so much. I'm now on my right, and I'm wishing with all of the faith that everyone remembers their numbers. I remember the lady with the red hair was number 1. Thanks.
Good evening, all. My name is Teresa Rulofsa. I am here tonight in the capacity as a parent. I reject the Bella Bill in its entirety. I will mention the 4 main reasons that I feel in this manner. Indeed, I do believe there are procedural flaws in the process. There has been procedural flaws in the process. Another concern is that there has been no stipulation of the input of experts such as expert child psychologists, where they have been part of the process. Number 3, it is not due to any one factor, but a number of factors that has led me to conclude that the proposals of the Bella Bill as it is unconstitutional, in violation of both children's rights and the rights of parents. And lastly, number 4, I do find it necessary. I am thankful that there is an extension to the 17th of April 2024 for the revision of each of the clauses of the Bella Bill. Thank you.
Thank you. Thank you so much. I just need to note that the extension isn't for the public. The extension is for the Western Cape to submit all of our input. The reason was after the Western Cape wrote, I think we wrote 5 letters, 6 letters, 5 letters. We wrote 5 letters over 2 or 3 months. And then the Western Cape this morning received official letter after we submitted the provisional negotiating mandate where we indicated that we did not believe the views of the Western Cape were sufficiently represented. And we again asked for extension, and we have received an extension to the 17th of April to make sure that all of our submissions are included. So I just wanted to make sure, I don't want people feeling that if they send a submission on the 5th, that why haven't we looked at it? Thank you. The second person. Ma'am, just remember to put your mic on.
Good evening, everyone. My name is Melanie Blanche. I'm an admitted attorney. I've been practicing since 2001, which is 23 years of experience. I specialize in children and family law. And the proposed amendments signify a clear intention to increase authoritarianism and centralized government control. It clearly indicates a reluctance to respect, protect, promote, and fulfill the values and provisions of the Constitution. The aim of the School Act originally was to form a cooperative partnership between SGBs and government, which is now clearly being infringed upon. Some of the issues I have, and I'm not going to deliberate this in detail, is Clause 4, where government controls basically all admissions policies. Clause 5, language, where it says very clearly that the HOD will have final authority in these policies. Clause 15, which gives the HOD the decision-making powers to withdraw the functions of governing bodies or to dissolve the governing bodies if they found it on reasonable grounds. The only way to appeal to this is to the MEC, and if this is not clearly centralized government control, then I don't know what it is. It clearly transfers the decision-making authorities of SGBs to the heads of department. Section 14 deals with the procurement of learning materials, which the HOD is not governed to do. I would like clarification of Section 26 I want to know why a political head such as the MEC is involved in operational matters concerning SGB's transactions such as loans, lease agreements or overdrafts. This act strong arms everyone involved in this act. It refers to imprisonment more than 16 times. I reject this bill in totality due to the fact that its covert intention to centralize government control is not clearly explained, defined, and the public does not understand all of this. And until the failures is properly addressed, and I refer to the addressing of overcrowding, the funding model for compulsory grade R, blended learning material deficits, learning dropouts, the fixing of crumbling school infrastructure, poor quality of teaching due to the strongholds of the school unions, and overcrowding in schools due to the insufficient number of schools. These things should have been addressed, not taking away the powers and authority of SGBs and parents. I thank you.
Number 3.
Good evening. My name is Pieter Terblanche. I'm the servant leader for #Hope for SA, a father of twins, and I'm speaking on behalf of children and protecting our children. I want to make a general comment that the Bella Bill is rejected because it's supposed to supposed to give us more responsibility as parents and protect our children, where at the current moment, it's actually talking about the control of government in the act. So in general, I think we need to look at the general vision of what the bill is all about. It's supposed to protect our children. It's addressing a couple of issues, but it's not actually enhancing the education of our children. We're totally missing the point with this bill because it's all about control and law and not enhancing what is best for our nation. I want to focus just on clause number 3, and that's about pregnancies in schools. Number 1 is, why is there pregnancies in schools? All right, a 12-year-old or child in school is not supposed to be pregnant. The law don't allow children before 18 to drink something, but are they allowed to have sex? Number 2 is, if we go and look at where it's coming from, is the comprehensive sexuality education that's for the last 20 years teaching our children from an age of 12 how to use a condom, what's the positives and negatives, where to find condom. We should start at the root of the problem. Then we don't need to deal with pregnancies. Number 2 is education support supposed to do the work of the health department. So we're missing what is we supposed to do. We want to stand at the fact that the parents are supposed to teach their children where does sex need to go. It is a biblical fact that sex should be in marriage. It's a holy act, and it's not for children to explore it. So we need to get to the facts of what it is about. And the bill is missing what we're supposed to present. Thank you very much, Stream.
Thank you, Speaker. It was great. My name's Donovan Penton. I am a member of the ACDP, and these are the views expressed by the ACDP. We reject the bill because of its contents on the following reasons. Number 1, the Education Department admits this is an administrative bill, seeking to address administrative issues. The ACDP says this should be a child-centric bill, focused on children. Number 3, the bill must put the rights of families and parents first. Parents and children. This bill must implement the principles of the Children's Act. Number 5, the African Charter on the Rights and Welfare of the Child must also be implemented in this Act. Number 6, all early learning childhood development from grade 0 to grade R must be included in the Act. The compulsory age for schooling should not be extended for now, and this should rather be done in a later bill focused exclusively on early childhood development, and that this is agreed to after wide consultation with the sector and civil society. The increase of jail time imposed on parents who fail to ensure their children are registered for schooling is anti-progressive and anti-poor. This is social welfare problem, and this must be addressed through social welfare and the Children's Court. Research shows that fines increase children not going to school. I'm coming to a conclusion. Number 9, clauses on the school governing bodies must be removed so that research can be conducted on rejection of admission on racial grounds, and a national consensus reached on how to address this and if and when it happens. Small schools must not be closed without reasons. Clause 25 proposing section 33.4 must be removed on constitutional grounds as it discriminates against primary schools with under 135 learners.
Please conclude.
I'll conclude now. Home education, section 51, should remain unchanged with a few positive amendments due to the admitted lack of research and knowledge of homeschooling within the DBE regulations must be written in consultation with homeschoolers. This clause has been rejected by homeschoolers, and DBE must go back to the drawing board to reach an agreement, and also can support. Thank you.
Good evening, honourable members and committee. My name is Rian van der Berg.
Put off. Like the mic.
Is it on?
No, it's on.
The other mic
on.
is put off so that there's not two mics at the same time on.
My naam is Rian van der Berg. Ek is 'n Christen man and I strive to live by Christian and biblical values. I reject the Bella Bill and in particular clause 39 that amends section 661 of the South African Schools Act. With that, I would like to read you from our Bible, which I believe we all know, from Jeremiah 1 verse 5 that says, "Before I formed you in the womb, I knew you. Before you were born, I sanctified you. I ordained you a prophet to the nations." In the final committee report, the governing party were too scared to say how many opposed the bill because the majority of South Africans have rejected this bill. One reason people rejected the Bella Bill is because it is an abortion bill that allows the minister to make regulations concerning learner pregnancy with people she handpicks. The ministry doesn't really care about learner pregnancy. The policy of the prevention and management of the pregnancy is already a disaster as it is. The Department of Basic Education has forced the CSE and scripted lesson plans on schools, even though the Department of Basic Education's own research shows that the CSE does not reduce sexual activity by learners. The minister has apologized that it has taken over a year to table her learner pregnancy policy in Parliament for discussion.
Please conclude.
All of this shows that the ministry and DBE are not serious about the rally, about really solving the learner pregnancy crisis. They want to use the learner pregnancy crisis to smuggle in their agenda with their UN friends. With that, I conclude. Thank you very much.
Just like to say that my concern is the homeschooling, and also the language is obviously needs to be, a person needs to learn in their own language. And I think also when it comes to one's faith, those also need to be provided for. So I think that is fair to everyone. Then when it comes to the homeschooling, my thoughts were will the homeschooling curriculum and the parents' wishes be overridden? And I think that is very, very important, because we know, many of us know how very successful the homeschooling is and how the children flourish under that system. And the school system is not doing well, as far as we can tell. So why change a good thing to a bad thing? It doesn't really make sense. And other than that, I would say that I agree wholeheartedly with what other folk have said, that we are basically in opposition to this bill because it is taking away the parents' and the children's right to make their own choices and to make their own decisions on the education of their child and what is taught. So thank you so much.
Number 7.
Hello, I'm Inga Semple. I'm a past high school teacher and also a past homeschooler. I have taught in both systems, and my sons have successfully completed, and the one has successfully completed his tertiary education out of the home, and so has the other one is in the process of completing his tertiary education. My problem is with this section 35, the clause 35. Those who clearly wrote this have no understanding of the education process. Each child is unique, and I noticed when I was teaching in the high school in 1987, I was part of the English department, and we had to push children who had failed their English exams into the next grade. And I noticed when I was homeschooling my own sons that they're able to fast track themselves into in subjects that they're good at and take their time in subjects that they struggle in. And so I just found that why can't homeschoolers have their own curricula as well? Some curricula aren't actually labeled grade 1 or grade 5. They're labeled with other with colors or other criteria, and they go from one level to another, but it doesn't kind of vilify a child who's actually struggling in maths or English. And so I just feel this is actually, it's crazy, because why don't the education department, basic education department, focus on the problems in the schools rather, where they've got huge dropout issues, overcrowding, absenteeism of staff and children, instead of forcing home educators to educate in the mode of a school system where they're going to have to pay for independent assessors who have no understanding of the process. So that's my feeling very strongly. I reject the Bella Bill in its entirety.
Thank you. Number 8.
Hello, I'm Renal de Villiers. I'm a clinical psychologist and a Christian, and I also reject the Bella Bill. First of all, I want to speak about mother tongue education. In the formative years, mother tongue education is so important to assist the child in concept formation, in critical thinking and analytical thinking, problem solving, and also in creativity. It helps to frame the child's experience of emotions and of their thinking. It also roots them in their culture. So for the head of department to make a decision about the language of a specific school, to me, is unacceptable. We need to look at the importance of mother tongue education in the formative years. The second thing that I want to raise, and this I see very sadly too often in my practice, is the impact of the CSE, where children are sexualized way too young, where they start sexting one another, they're sending sexual texts to one another, where they get exposed to pornography, where they learn how to negotiate sexual encounters with one another. And we're talking about kids of 11 years old. So my heart is really sore when I work with kids and I see how they have been sexualized way, way, way too young. And so then we are surprised at our pregnancy rates at school. But the problem started way earlier. So, also when we look at what hasn't been discussed tonight, the ECE toolkit, it has just been kind of surreptitiously brought in as a pilot study in KwaZulu-Natal to train teachers how to ostensibly gently help kids who want to sexually transition. But the parents are kept out of that. Kids are incredibly impressionable. They are at an age where to please the teacher is a very important part of their daily life. So that impressionable child is now listening to all these fancy terms being bandied about sexual transition, about changing your body. And they take it as, well, that's the going rate, that's cool. But what I see in my practice is that a child who is sexually confused, in terms of gender confusion, sorry, I need to say, gender confusion, often as a young adult, that confusion has disappeared. But now, if a child is made to undergo a sex change operation, what happens then? The child has been mutilated. Just because adults decided that they know better. And the parents are vilified. In America already, the parents are actually criminalized. Kids are taken away from the parents. And the child is operated on. The child is not like we say in Afrikaans, is nie mondig nie. But the operation has taken place. We need to wake up. We need to realize what we're doing to our society and to our children. It is not enough to say we're living in a secular society. I want to say that's rubbish. We are parents with beliefs. I'm a Christian. There are other parents who share my Christian beliefs. There are other parents who might say, I'm Muslim, but I believe in the sanctity of life.
Please conclude.
Thank you. I think that is enough, but I feel very strongly about it. As I said, I'm speaking as a psychologist. I see the damage in our office. I'm speaking as a Christian, and I feel deeply about this. Thank you.
Lucky number 9.
Geagte voorsitter, my naam is Leendert Stoop, ek is die voorsitter van die AfriForum Durban Wiltak. Ons is teen die Bella-wetgewing vir die volgende redes. As jy kyk na artikel 4, gemeenskappe sal hulle seggenskap oor toelatingsvereistes by openbare skole verloor, wat voller klasse en dus swakker gehalte onderrig gaan beteken. Artikel 5, provinsiale onderwyshoofde sal finale gesag hê om oor die skool se taalbeleid te kan besluit en die beleid moet die breër gemeenskap verteenwoordig. As dit sal die einde van Afrikaanse skole beteken en inbraak maak op artikel 29.2 van die Grondwet van die Republiek van Suid-Afrika. Die provinsiale onderwyshoofde wat die finale sê oor die skole se toelatings en taalbeleide sal hê, is staatsaanstellings en politieke aanstellings en hulle het hulle eie ideologiese agendas. Ons sien dit reeds. Artikel 14. Nog magte wat aan die staat oorgelaat word, sluit die sentrale verkryging van onder meer leermateriaal in. Indien dit so aanvaar word, sal skole in die toekoms dalk verplig wees om enige leermateriaal deur die staat te bestel of om ondernemings te gebruik wie die staat sê hulle moet gebruik. Dit skep verdere risiko's in 'n land waar staatswerkers miljarde rande per jaar steel. Belastinggeld wat ons betaal, steel hulle. Die staat gee voor dat hierdie wysigings nodig is om skole teen onbevoegde beheerliggame te beskerm, maar daar is reeds voldoende wetgewing om sodanige beheerliggame te verwyder. Bepalings in die wetsontwerp bots met die grondwet, bestaande wetgewing en uitsprake van die konstitusionele hof. As dit so aanvaar en geïmplementeer word, gaan daar verseker hofsaake teen die staat gebring word. En weer eens gaan ons as belastingbetalers daarvoor moet betaal. Hierdie voorgestelde wetgewing bevorder die sentralisering van mag en dit dui eintlik op 'n sosialistiese regeringsstelsel wat teenstrydig is met die demokratiese beginsels van ons grondwet. AfriForum sal hierdie in die hoogste hof beveg. Dankie.
Lucky number 10. Who's number 10? And then I'm moving over to the persons from
Hi, my name is Gareth Kelly. I'd just like to state that it's my God-given responsibility as a father to teach my daughter about sexuality. And it's my God-given responsibility as a father to decide if to educate her about having an abortion or not the school's right. I reject the comprehensive sex education and I reject the billable in its entirety.
I've indicated that I will now be taking the hands from the gallery, but in order to hear you, I need you downstairs at one of the mics. So if you're not downstairs yet, if you could make your way downstairs, if you do want to make an oral submission from the gallery. For those who don't know, this is the gallery on top. Okay. Are there anyone that came down from the gallery that I didn't see that wants to make an oral submission now? Okay, there's one hand, you're number 1. Okay, I just want to check quickly. Is there anyone in committee room 2?
Yeah.
Okay, there's no one in committee room 2, so we don't have to take hands from that. And then there's an Alna Wigman. I can't see her full name. And a Mila Harding that are online. So I will take Miss Elna as number 2 and Miss Harding as number 3 then. Thank you so much, in that order. If you can maybe just come to one of the mics in order to make your respective submission, please.
I reject the billable in its entirety. Clause 25 deals with closure of public schools, and schools with less than 200 children will be closed. There is already an issue of not enough schools, overcrowded classrooms, certain special needs conditions, ADHD and autism need to be in a class or school with fewer children, or they find it near to impossible to cope. If you close these schools, you fail to meet these children's needs. Clause 39 is an ambiguous clause and deals with management of learner pregnancy, but does not state how or what will be done to manage this issue. Why is children even being exposed to sex at such a young age in primary school? This can leave them with major childhood traumas such as depression, bipolar, and lots of other issues, and in some cases, suicide. Clause 2 is dealing with punishing negligent parents that doesn't concern the billable. It concerns the children's codes that have social issues to deal with the issue appropriately. I reject this bill in its entirety. Thank you for listening to me.
Do you note some people have come down from the gallery? I'm just going to take Ms. Wigman and Harding, and then I'm going to come back to giving you your numbers. Thank you. Ms. Wigman online, I'm putting up your timer now.
Good evening. Can you hear me?
I can, yes.
Good evening. My name is Elna. I object the billable. I do not agree with clause 2. It is common sense that you would first build your foundation, then your house, not the other way around. Firstly, the DBE should ensure that we have sufficient and good infrastructure, qualified educators, and a good curriculum to ensure that every child receives high-quality education. The DBE cannot enforce Grade R until the country is 100% ready and equipped for the implementation of Grade R. The SASSA nor the BELA cater for the registration of micro schools. It is not feasible for these small schools to register as independent schools. All these micro schools, which also include ECD centers, are beneficial. They would be shut down and fined as per clause 33. The curriculum is not the only important part in a child's education. Infrastructure is too, and a lot of schools do not have good infrastructure. In my opinion, home education should not be inferior to that of dilapidated schools. where children share desks, chairs, and books, and where the standard of education is extremely low. If home educators are restricted to cover 50% or more of the content and skills according to the National Curriculum Statement and assessed according to age and grade, then they will not have the freedom to be able to follow the variety of different approaches of education that are available worldwide. Home education prioritizes a child's education according to their abilities and stage of development in order for them to learn at their own pace. Age and grade have very little meaning. Home education is not school at home and therefore cannot be regulated as such. I completely disagree with Clause 35, Section 16. A minister should not have unfettered powers to make regulations at her sole discretion.
Ms.
All
Veltman,
decisions
please
should be made
conclude.
in consultation with home educators. To end, this bill does not contribute to the eradication of poverty. It does not provide an education of high quality for all learners, nor does it uphold the rights of all learners, parents, and educators. In my opinion, this bill is all about state control. Thank you for your time.
Thank you so much. And then Ms. Harding online.
Great. Can you hear me?
We can, yes.
Okay, great. I'm Mila Harding, and I'm representing Section 27. Section 27 strongly supports the inclusion of the head of department's oversight role over the admission and language policies of school governing bodies in clauses 4 and 5. However, we are concerned about the deletion of the obligation for the HOD to provide reasons for its decisions where it does not accept a policy, which was in the previous version of BELA. Provision of reasons is crucial for a proper appeals process to function and to ensure transparency. Additionally, the process is unclear regarding what is to occur if the HOD does not approve a policy and the SGB does not appeal that decision. Finally, we are concerned that the HOD may not have the capacity to review all policies, and thus we suggest, first, the establishment of an office to fulfill this function, and second, the establishment of an individual complaints mechanism. Section 27 also fully rejects the increase of criminal sentences for parents who fail to cause their children to attend school in Clause 2 of the BELA. Criminalization of parents is ineffective and against the best interests of children. However, if the criminal sanctions on parents are to be kept, these must be made subject to certain considerations to protect the best interest of the child. Finally, we recommend that Clause 8 of the BELA is revised to insert alcohol into the list of banned substances that are prohibited on school premises. The most effective way to protect children from being exposed to alcohol is to have a blanket ban. Thank you.
Thank you so much. We have no further hands online. I saw the lady in the leggings come in first, and then I saw the lady with the red hat come in second, and then everyone after that, please know you are 3, 4, and so on. Thank you so much. Just want to see, I think there's a mic on that side, and let me just see where another mic might be. Okay. Okay, perfect. Thank you so much.
Hello, my name is Dr. Joy Levine. I'm an early childhood educator and an academic. And firstly, I would just want to say that it is the responsibility for government to represent the people and for people to watch out for power grab, which we have seen so much in this country, and to take away the school governing body and the parents' rights, I would say, is a Trojan horse for what can come afterwards, even if it is about language and policy right now. I am also an early childhood educator, and I believe in a play-based curriculum. I'm a Waldorf teacher. There are many systems, and small home-based schooling is the best for the development for early childhood. Therefore, to push them into grade Rs, which can be far from home, can make them very, very vulnerable, and as we've already said, overcrowded, where teachers are unable to really provide an age-appropriate curriculum. I worry about when we talked about the school governing bodies having financial interests in the schools, what about external entities such as UNESCO who are coming into this country? And we've already talked about the white elephant, which is comprehensive sex education, getting grade Rs earlier and earlier to learn how to touch themselves, be touched by others, and for children to lose their defenses. This leads into the abortion law, which once again enhances the fact that we are allowing industries of drugs for prevention, for changing sexes, for abortions into our schools, and I think we should be extremely cautious. Thank you so much. I reject this bill fully.
Thank you very much. I greet you all in the house. My name is Nongaba Eunice Duna from the South African Democratic Teachers Union, a chairperson of the region called Lydia Simons. I'm standing here as a high school teacher who has, in the past 2 weeks, experienced miscarriage of a learner in a corridor at school. It is a very bad experience that you may not want other learners to see. But the problem is, this bill, we accept as SATU, but we need, especially in this clause, to see to it that there's improvement in school facilities. In terms of us, when we grew up, there were sick days at school, which can be assisting us, you see, to hide these things when they happen from the eyes of the smaller ones, especially. We may say smaller ones, but they are also affected by pregnancy. When you look at this issue, damage has happened. Damage has happened. They are being raped from home. It is not all lovers' pregnancies that are there. Raped in the society. We need to look at the social background, where these learners that we are teaching are coming from. Therefore, as we accept this bill, we need just amendments to be done in terms of looking at facilities at schools. I'm adding to the point that was raised here in terms of her sister and psychologists. We've been crying about psychologists in schools to be in full time. You see, just like the policemen that are there full time for crime. And we need to look at this part that is affecting the women, children, that we need to see them being leaders just like us tomorrow. Thank you very much.
Struggling to see who was third. Oh, yes. Okay.
Ladies and gentlemen, everybody here has a different worldview, a different culture, a different religion. We all come from different backgrounds, but I fully believe that each one of us has a right to raise their children as they see fit, regardless of where you're from. So I reject the bill in its fully and in its entirety. And just before we end off, my view is of a biblical view, and Proverbs 22 verse 6 says, "Train up your child in the way he should go. Even when he is old, he will not depart from it." Thank you.
Okay, I think those from the gallery are scattered everywhere, so please assist me. So yourself, and then I just want to see who from the gallery was next. Is the person upstairs, outside?
No, by the door.
By the door.
The ladies.
Oh, okay. Sorry, I thought you were pointing up. Sorry. Okay. Okay. Thank you so much, ma'am, with the hat. I'm just going to ask that if you have made a submission previously, because it is 4 minutes to 8, if you have made a submission previously, I'm going to repeat the written submission process just so that those who haven't had the opportunity are able to make their respective submission. Thank you.
Good evening, ladies and gentlemen. Madam Speaker, I'm Julian van Wyk. I'm a retired teacher, but I'm still busy at school because my concerns is the language and mathematics in school, life skills. So I'm still at school because once a teacher, if there's teachers here, always a teacher. And the best teacher is the parents at home. I reject the valuable because there's many things that I don't go with. First of all, early childhood development is very important. And here I read in section about, in the section I read, and it's been brought up by the speaker that spoke first about if the school governing body doesn't have anybody that can speak out at the school, they must co-op. To me, that's a concern, because if you co-op somebody, they don't know your children, they don't know what's happening at the school, you co-op that person comes in, they're not even aware what's going on at the school and they have to speak. So I don't agree with it. Secondly, the DBE books that they wrote for the children that they're currently using in schools. We all come, like the previous speaker said, that we all come from different societies, different backgrounds, different. So we in the colored community, I would say, and the overcrowded classes, oh my God. I also stand on Christian values and principles. It's not easy. That's why, don't get me wrong, I'm not putting a feather in my hat, but I'm concerned about the child. That's why I never stood off of teaching. I go as a volunteer into the schools because the children need help. The schools are open for special needs. We're supposed to have that in the schools, but I see the overcrowded classes, how the teachers struggle, because we are doing harm to that child that needs special attention. You're sitting with 49 in the class, they need your attention. So that is for me a big issue. And there's a lot of things in the clauses of the Bible that I don't agree with, because I want our children to be protected. And may God help us as parents, educators, and so psychologists, social workers. And that is also a big problem to me. Before there was LSAN teachers in the schools. Now LSAN teacher must take 3 schools. They must be at this school, where this is. They must go to your school. They must go to that man's school.
Please conclude.
So it's 3 schools that they have to see to. When are they going to reach the actual child? So that is my concern. Thank you, Madam Speaker.
I'm going to see if there were people that perhaps seated from the gallery that I'm missing now. Yes, it was the lady in the blue and the gentleman. Reverend, I know you did make a very long submission in the previous session and you've disregarded my rules also when it came to time. So I am going to give preference to those who have not made a submission. I'm going to give a preference to those who have not made a submission because we are over time. Because this would essentially then be your second bite. And just note, it won't make a new submission. It would essentially be a supplement. And I would encourage you to do it in writing. Ma'am in the blue. Oh, sorry, in the black. Sorry.
Hi, sorry to interrupt at the last minute, but it's fitting. I'm Michelle Forster. I'm a retired preschool teacher and I've had 40 years experience. So I am a qualified chaos coordinator. And for my hobby, I'm insanely curious. So I've joined a lot of global groups and I want to tell you that you're all in a very good place. Where everyone else here is feeling terrible. As I'm heading towards 70 at speed and I've seen a lot of decades, this has happened. It's got to happen. The world is doing this all over the world and we're breaking apart. But it comes together in a better way. And you being here is part of the answer. The only way you're going to be positive is to keep doing what you're doing, but multiply your efforts. Because if you look at global trends, this is happening very, very much all over the world, but it's not just homeschooling, it's deschooling, unschooling, world schooling. They've got every sort of name for it, but it's statistically backed. Schooling is $1 trillion business. They're going to continue forever. We need somewhere to park the children, but you need the homeschoolers because you can't cope with what we've got. And South Africa has it bad. So to work together is what you've got to continue to do. But the best way to do it is to keep multiplying. And the quickest way to multiply as a preschooler, I don't teach my kids, they are creative geniuses in when they're 5. They get statistically dumber in their creativity. No, I don't put my system down. I'm a product of it. But you've got to let them the power of infinite thought and infinite possibility. So you don't just teach 1 and 1 is 2. 1 and 1 could be 11. 11 is a master company, or you could do the power of 0. What if I multiply that by 0? Now I've got 110 people. So instead of having one-on-one conversations, you can get together. If one person gets 11 people, or one person, 11 people get 10, you've got a bigger room. You've got to start spreading it because change has always come through the people. But you've got to get more intelligent. You've got to get more informed. You've got to get more powerful. And the good news is that the stages we're meant to be going through, which we're going through a stage of change, which was dictated by digitalization, and it meant we went on through demonetization. The final 6th stage was depolitization, which is what we're going through now. And people are unhappy with politics. We need to be. They can't. We've got wonderful politicians, but there's always 2 sides. So it's the dance between the one side and the other. It's not the dark and the light, or the wrong and the wrong, the right and the wrong. It's basically what I read the definition of war the other day was. What's the definition of what's right and what's wrong? There is no right or wrong. It's who's left. So if we can get together in any way, and I can be of any help to anyone in this group, merely because I have a ton of information that is not really relevant to me at the moment. I only found out about this meeting today because of a very concerned parent. And it's exciting to see you people here. So if anyone needs any information and I can do anything to help your cause, I just applaud each and every one of you for your passion. But take some peace, because when you are in this place, it is chaotic, but it gets better day by day, and it only gets better by our passion, because it's the only thing that's ever changed.
Thank you. In the white. If there are anyone who arrived with the WCPP transport, the transport was booked for 8 o'clock. So I just ask that you please just make your way to the respective transport, please. Okay, so in the white.
Hi, good evening, everyone, chairperson. I'm Marius Bailey from the People's Movement for Change. I am an admitted advocate, but also currently serve as the Deputy Secretary General for the PMC. From the PMC, would like to know what has happened to the notion that it costs a village to raise one child. We feel that the department is missing the point. If we go to the Constitution, it clearly says that everyone has the right to basic education. And this is what is missing in your presentation. Instead, what we hear is a lot of sanctions that you want to impose on the very same people, being the parents that wants to give basic quality education to their children. We are products, most of us here, of basic quality education by our own parents. So what we are saying, we join the millions of people in South Africa to reject the Bella Bill in its entirety. What we rather want to propose, Look at the standards, the current standards of just to get to the next grade. 30%, it's ridiculous. Rather improve the standards. We want to improve our country, improve the quality of the education. So PMC feels, let's rather Department DBE, go to the drawing board, go back to the drawing board. I don't think we are against education, especially for our kids. But what we say, there can be no education without the parents. We know as parents what is best for our children. Allow us government by the people, for the people. So listen to the people. And we say tonight, if you allow us to withdraw this bill in Parliament, then we will consider voting for you in the upcoming elections. If this government don't withdraw this bill, then we say with millions of people in South Africa, then the ANC must go. Thank you.
With that, I don't see anyone else that was in the oral submission line, and we are 8 minutes over time. The members know I can sometimes be quite particular with time, but I just want to repeat some of the written submission avenues for those who chose not to make an oral submission. A reminder, the deadline is midnight tonight. So if Ms. Hassan Musa gets an email from you at 1 o'clock in the morning, it's not going to be included. The email address, which is also on the website, is W for whiskey, H for hotel, M for Mike, O for Oscar, O for Oscar, S for Sierra, A for Alpha, at wcpp.gov.za. I'm just going to repeat that. WHMOOSA@wcpp.gov.za. There's also an online submission form that we created where you can put your name in, where you're from, how you feel, do you want amendments, do you support, do you not support, submit. It's also on the website. You can also do a WhatsApp. To my knowledge, when we introduced this in Budget Committee, we are the only provincial parliament in South Africa, quite frankly, that uses WhatsApp as a method of public participation. So if you want to send us a thesis on voice note, that's fine. 081 498 6075. 081 498 6075. I cannot promise that Ms. Hassan Musa won't put you on 1.5 when she listens. But with that, colleagues, the DBE will be required to respond to the respective submission process that the Western Cape has received. And this essentially brings us to the end of the last public hearing for the Western Cape. The next process, just for those who are interested, the matrix will now have to be put together. And I do not envy our procedural officer, because as of yesterday, we had over 5,300 written submissions. That excludes the oral submissions that we had at public hearings. And we've had, before the Cape Town 2 sessions, over 2,700 people in attendance. So those are all submissions that the committee will have to meaningfully consider and have to make a decision on regarding the Western Cape position to submit to the NCOP, which is due on the 17th of April. The NCOP will then go clause by clause through the different provinces' submissions. And if it has amendments, it will send us a new bill. If it doesn't have amendments, it will send the same bill back. Then, based on whatever they send back, the committee will have to meet and decide how it feels about the final bill and submit a final mandate, which currently is due on the 24th of April in the NCOP. But you're also welcome to subscribe to YouTube. You can check our committee activities on PMG, which is an independent organization that tracks the Western Cape Provincial Parliament. And yes, I just want to say thank you to every single person for showing up. Irrespective of your background and your views and your ideology, every person here showed up for their children, for their schools, for their SGBs, and for their communities. And for that, I want to say thank you from the bottom of my heart. The meeting is thus adjourned.
Thank you.